Hi, Michael Kushner here. Welcome back to the podcast, HOA HELL. With me today, as always, is my co-host and senior associate from MBK Chapman, Sam Kill. Sam, good morning.
Good morning, Mike. How are you?
I'm fine, thank you.
Glad to be back with you.
I'm glad you're here.
Thank you.
Sam, today we are going to be covering something that we've never discussed in any episode, that I've never discussed in any of my articles on the website or my fact sheets. And yet it's something that comes up all the time. Here's how this happened. You know how early I get in. Mm-hmm. I get in very early in the morning. For those of you who listen to the podcast, you know I get in before 3 a.m. That's just part of my daily routine. And I will spend a bit of time in the early morning going over emails that are from other, not my normal email address. In particular, at the end of every podcast, I always invite people to leave comments or ask questions. Mm-hmm. And in the description, there's an email that they can send those emails to. Yeah. And I look at those and I answer a lot of them pretty briefly. And I got in this morning at my normal time, and somewhere in the early 3s, I opened up an email and I read this very good email from a listener who asked this question. And I realized, holy moly, I've never discussed this before. And this person commented that they looked on our website, mbkchapman.com, for looking at my articles and fact sheets and couldn't find one on this topic because it doesn't exist. Mm-hmm. And it was such a good question and such a good issue. And I can't believe that we've never thought to add it to our list, so that I immediately decided, okay, we're going to do a podcast episode today. I'm going to surprise you when you get in, and I'm going to write an article. So I wrote a fact sheet. So I already published the fact sheet early this morning, somewhere in the 3s. But I gave this person a detailed answer because I knew that I was planning the outline for this podcast and that article at the same time. So I figured I'll just knock out 3 birds with 1 stone. So that's what we're doing here. And you got wind of this topic 5 minutes before we came in to record this podcast.
Yeah.
You have everything that I get from you today is going to be off the top of your head with no review or preparation to make sure that you're thinking of the right statutes, et cetera. So forgive me for that, but that's just the way the cookie crumbles.
No. Hey, credit to you and the homeowner, the questioner, for raising such a intelligent question and such an important topic, because based on our brief discussions a couple of minutes before recording, it's profoundly important for associations and the broader membership as a whole. And I'll let you get into it.
Yeah,
but yeah, no,
happy
to be part of it.
I can't believe we've never covered this issue. The long and the short of it is, there are a variety. The Business and Professions Code in California sets out the requirements for the kind of work that requires a contractor to have a license, and sets out requirements to when a licensed contractor is obligated to perform work versus you can use somebody that's unlicensed. That's in the Business and Professions Code, okay? There are sections of the Labor Code in California, one in particular that we're going to talk about today, that touch on this issue, the issue that's going to be at issue today. And the basics today are, and this was kind of the nature of the question that was posed by this homeowner. Mm-hmm. This homeowner said, basically, I live in a townhome that's not classified as a condo. It's a PUD, okay? The HOA is responsible for the roof, and they have there's some damage to the roof, and they are hiring a roofer, a roofing contractor, a C39 license holder, to come and perform work. And what I want to know is whether or not I have a right under the law to ensure or confirm that the contractor coming to do work on my roof is licensed and has the necessary workers' compensation insurance before he or she starts work.
Yeah.
And I really did. I leaned back in my chair in my office. I went, that is a great question. And I knew the answer to that question, but I didn't know whether or not the statute was specific. So I went and looked at a couple statutes. I knew where to look. And my answer to the person was, in short, the statutes, the relevant statutes in the Business Professions Code are not specific. They don't explicitly grant you that right to check their license status or workers' comp status prior to work being performed, but the law strongly implies that right exists, and therefore the answer is yes, it does. Mm-hmm. Not because it's explicitly set forth in the law, but because it's so strongly implied in the 2 or 3 statutes at issue that I say you do. Mm-hmm. That was the long and the short of my answer. And then I said, now I'm going to write this article. And then after I wrote the article, I wrote the outline for this episode. And that's what we're going to talk about today. The Davis-Sterling Act doesn't expressly grant a pre-work right to review certain documents or to confirm these issues, but it's strongly implied. And therefore, I'm going to argue that you do have that right. But you raised a very great issue while we were having our 5-minute talk. And I think now's a good time to talk about it. And this is the issue where you said you're asking a technical question, but it also delivers a backhanded message to the HOA. What did you mean by that? And kind of explain to them what I'm talking about.
Yeah, I think what you're alluding to is obviously, kudos and credit to the homeowner for raising such an interesting one, and it's a nuanced one.
Very.
But it's something you would expect of a sophisticated party because it triggers many rights and potential. Exposure to liability.
Serious, catastrophic.
So although he's asking a technical question in terms of, can I do this preemptively prior to the work commencing, right? On a component that the HOA is responsible for. The part that I think you're alluding to is, I think I framed it as it also serves as a notice element to the association, a warning, as in if you haven't done so yet, if you haven't checked all the boxes, if you haven't done your normal investigative and due diligence duties, which is part of, by the way, the board's fiduciary duties, critical to this issue.
If they don't do it, it's gross negligence and a breach of fiduciary.
Now is the time to do so prior to the work commencing.
Right. Without ever saying that.
Correct.
Just asking the question, I would like to confirm the following 2 or 3 items before this person steps foot on my property. Can you please give me that confirmation? Mm-hmm. You're not saying you better make sure that you've done your due diligence because you have a fiduciary duty to ensure that you're hiring licensed professionals and not using an unlicensed or an uninsured or a handyman, right? Mm-hmm. You're not saying any of that, but you are saying that.
You are saying that.
Because what you're saying is, if the answer is no, you should make sure it becomes yes before somebody steps foot on my property.
In a way, that's an opportunity to cure if there's an omission. Yeah, exactly.
No harm, no foul in this case.
Yeah.
If the person hasn't started, there's no harm, no foul. Mm-hmm. Okay? And by the way, the beauty is if, let's say you already signed a contract, person's not licensed, contract's void anyway.
Indeed.
So it doesn't matter.
Yeah.
Okay? Now, why should a homeowner care about this issue? Well, I'll tell you why. I used the word catastrophic a minute ago, and I'm going to tell a story very shortly about a case that I handled through this firm several years ago before Sam became a senior associate here. And it touched precisely on this issue, and it illustrates exactly how catastrophic this very particular issue can become for an HOA or a homeowner. Mm-hmm. In the case of my case, it was a homeowner, but it only because there was no HOA involved. But it could have very easily been an HOA, and it would have been the same thing. Mm-hmm. Okay? And I will say, by the way, just for fun, just so you know, mistakes happen. We spent 30 minutes recording this very episode only to find out that I hadn't pressed the record key. So we've already talked about this morning. we thought we were filming this episode a while ago, and we weren't. So we're doing this the second time through, but I thought I would say that to you because it's like a blooper. I looked at the timing while we were talking, and I realized it still says 0. And he saw me freeze and look at the screen and not take my eyes off it. And he said, what is going on? So anyway, all right. The point is I'm going to get into a story that shows you how catastrophic this could be. Mm-hmm. And then we're going to talk about the nature of the rights involved, what a homeowner can do to protect not only him or herself, but also his or her HOA, because ultimately, and one of the things Sam will talk about later is what happens if things aren't as they should be and somebody's hurt or there's significant problem. I'm not talking about minor stuff. I'm talking about he had a case, and he's going to use this example about a case he handled where it was a wrongful death. Somebody actually, during the course of scope of work being performed and unlicensed and uninsured, somebody fell, got killed.
I mean, might as well just say it.
Well, let's do that later. Let's do it later.
Okay, all right.
Let's do it later.
Yeah.
When it's appropriate time. But he's going to talk about that case and what that means in real life to every homeowner in that HOA. So let's talk about so we know why this is important. This is a great question. It's an important question because if you don't dot your I's and cross your T's when it comes to licensed contractors and proper insurance that's required by law, then the consequences if something happens, and this could be property damage or damage to a human being or even a death, liability could be to the point of catastrophe. It could be life-changing, catastrophic, and it's so simple to avoid. So that's why this is important. Let's start with Civil Code 5200. We talk about, that is probably the most commonly discussed Civil Code section, part of the Davis-Sterling Act, that we mention in this podcast. I would venture to say we've covered it in over 24 episodes.
Oh, yeah.
Okay? Yeah. And in that many articles and fact sheets on my website, mbkchapman.com, under the Libraries tab. You can look at articles, you can look at fact sheets. You go into the search bar in there, type in 5200, a whole bunch of stuff's going to come up. It is one of the most powerful weapons that a homeowner has. It's so important and so monumentally a great right given to homeowners under the Davis-Sterling Act that it is an entire chapter in my book, HOA HELL. It's already an Amazon bestseller, and it's still on pre-order. It comes out in general distribution on December 15th. Chapter 4 of my book, HOA HELL, is dedicated exclusively to the power of 5200 and discussing how to utilize that to the maximum extent permitted by law to get all the documents that you want. That's how important 5200 is. So it feels good and natural to start with 5200. Mm-hmm. You have a right as a homeowner under 5200A4 and 5200A11 to ask for, in that respective order, a copy of all contracts between the HOA and a vendor, including a licensed contractor or an unlicensed contractor, as it might be, and copies of any insurance policies, whether they be general liability or the all-important and required workers' compensation insurance. Because every contractor, unless the owner of the company is doing all the work by themselves, which I've never seen ever in my life, is going to have employees. Not independent contractors. Those people that show up to do the grunt work, they are not independent contractors. Whether or not they're labeled that by their employer doesn't make them independent contractors. They're employees. So 5200, we start off right at the bat. Those are two sets of documents you want to ask for. If your HOA doesn't give you what you're asking for right away, you do a formal demand and you tell them you're not going to allow anybody on your property to do any work until either you get those documents or the timeline set forth in 5200 lapse. And in this case, it'd be 30 days because there are 10-day requirements, but that's for financials. There's a 5-day requirement, but that's for a membership list. And then everything else is 30 days. The two things we mentioned didn't fall into those other categories, so it's 30 days. So either they give it to you before 30 days voluntarily, or nobody gets on your property until you've received that after the 30-day period runs. So they should, if they have nothing to hide, they should just be happy to give you copies of what you asked for because you have a right to those things. Statutorily, there's no dispute. You have a right. Okay? So let's go into the hard stuff. Business and Professions Code. Do you know one of these off the top of your head?
Business and Professions Code 7048.
That's right.
This would be where...
And 7058.
Correct. And 70558 would be the one pertaining to especially such a roofer that you mentioned.
7058, not 70558. 7058.
Right, 7058.
Yeah.
7058. To be precise, 7048 and 7058. Exactly. The 7048 Business and Professions Code section pertains to supplies and work done in the amount of $1,000 or more requires to be by a licensed contractor, essentially.
Let me put that in English. You just said that like a lawyer. Let me Englishize that, okay? To the extent that the kind of work being performed requires a license, and that's all set forth in the Business and Professions Code. We aren't going to go into those sections. They're not directly relevant today. To the extent that license is required, the work performed that requires that license must be performed by a licensed contractor if the work and the supplies are $1,000 or more. It's that simple.
Yeah.
So I've hired many a contractor in my life. I've hired plumbers, I've hired painters, I've hired electricians, I've hired lots of people. And they're always 1,000 or more, okay? They're never not, okay? And that's excluding supplies, but this actually includes them.
Oh, yeah.
So it's going to be that. So 7048 says that to the extent that a licensed contractor is required, that licensed contractor has to be used if the job's going to be 1,000 or more. And that job is defined as not only the labor, but also the supplies involved, okay? So in addition to that, 7058 goes into those subcategory specialties. There are certain areas of construction in California that require not just a general contractor's license, but a subcategory specialty license. For example,
like the C39, yeah.
C39 for a roofer.
Yeah.
We have some cases now involving roofing, and that's why it came to the top of your head.
Right.
Mine too. So C39 is a roofer. Okay. Electrician is one of them. Painter, roofer, plumber. Those are some of the big ones.
Yeah.
There's lots of them, and there's these categories that are required. 7058 kind of addresses that, but it's not important to go into the details. What's important is you can't have a handy person who's unlicensed under the Business and Professions Code, who's does not have the adequate license for the work being done. You cannot have that person perform work to the extent that it's over $1,000. End of story. Meaning that you have to have a licensed contractor. Let's just say that. Licensed contractor is a contractor who's got an active participating license number from the California State Licensed Contractors Board. And you can verify that for free on their website. You can Google CSLB license check, and it'll lead you right to where you need to go. And you type in either the name of the company or the name of the contractor, and boom, it'll come up. If they don't come up, then they're either operating without a license or they're operating under a name different from the one that their contract says, which is illegal too. So then you would just simply call up the company and say, hey, I've got this contract, but I can't find you. Can you give me your license number? And then you can plug that in and find the actual right place and find out. The point is, it's easy to find. It's easy to verify. It takes no time at all. But if the HOA doesn't do it, breach of fiduciary duty, gross negligence.
Oh, yeah.
Okay? So why is that important? Well, I'm not going to say, oh, it's important because that's what the law requires, because that's not really why it's important. Why it's important is because the consequences for not having that license are what lead to the catastrophic potential liability to not only your HOA, but in some cases you, the homeowner, depending if the work's being done on your property.
Right.
Okay. So before we get into the example and the catastrophe that could happen, let's talk about the other thing. It's not enough to be licensed. You have to have workers' compensation insurance.
Yeah. Insurance
because
is huge.
You're going to be having, as we already proved, it's not going to be the owner necessarily doing all the work. There's going to be some employees. He or she, that company, that contractor is required by law to cover under workers' compensation coverage, cover all employees, okay, for injuries sustained in the course and scope of their duties. In the absence of that insurance, the homeowner, or in most cases the HOA, is going to be liable for any injuries that occur to that worker. That's who's going to get it, okay? So they better be in compliance. Now, if they're unlicensed, they probably won't have workers' comp. If they are licensed and they don't have it, you're still screwed.
Yeah.
Okay? Now, they'll lose their license for that, but that doesn't help you with the cash that you're going to have to outlay. So you got to check both. And so the best way to check it, let's assume it's just the HOA liable. We'll talk about how you could be liable later, but let's say it's just the HOA. You ask for a copy of the contract or the name of the contractors. You can check the license number, or even give me the name of the contractor and their license number so you can check the license number and not look for it. And let me see a copy of a current certificate of insurance for workers' comp. Make sure it's active. And another thing is the HOA should probably insist on being named as a secondary or an additional insured.
And most good ones do. Absolutely. Yeah.
All good ones do.
Oh, yeah. Yeah.
And that's standard. And no contractor is going to be offended by this or surprised because it's common and standard.
And by the way, needless to say, but just to say it for the audience, none of that information is privileged or personnel information that needs to be redacted or withheld. They need to provide that to you under 5200.
End of story. And I gave you those sections already. Okay? You have an unfettered right to those documents, unredacted, and you should get them. Okay? Now, obviously, the workers' comp coverage is there to protect everybody. It protects the contractor from being liable for the injuries that they should have covered. It protects the homeowner or the HOA in most cases from having to assume liability or their insurance assuming liability when there's lack of coverage. And it protects the homeowners of the HOA from having to cough up a amount of money in a special assessment if there's no insurance.
Right.
Protects everybody. It's a good idea. And in the absence of it, we've got a gross negligence issue. So now let's talk about the consequences of using an unlicensed or uninsured, but unlicensed contractor. And I want to focus on California law, and it's going to be not in the Davis-Sterling Act and not in the Business and Professions Code. It's going to be in a place that you guys aren't thinking of, and that's the Labor Code.
Labor Code.
2750.5. 2750.5 specifically states that use of an unlicensed contractor where a license is required renders the worker an employee of either the homeowner or the HOA, whoever the employer is. In the case where work is being performed on your home, and we'll get to that scenario later, the two of you are probably going to get named, the homeowner and the HOA, as co-employers. That's going to happen. In other words, the Labor Code says in California, if you're not licensed, but the work requires a license, then whoever hired you is an employer, and all of the obligations that go with being an employer-employee relationship carry with, including agency theory. Let me give you a scenario. Sam is an employee of this law firm. Sam's going to court. Sam is maybe not paying attention in traffic, not to say that you do this, but maybe not paying attention in traffic, looking at texting. Anyway, gets in an accident. I'm going to, as the employer, our law firm is going to get sued. And we're going to be responsible because Sam was acting within the course and scope of his duty. He wasn't drinking and driving where I could maybe say that was outside course and scope, right? He was on his way to court. He was doing his job, lost, just wasn't concentrating for a period of time or whatever. Normal negligence, I'm responsible because my employee is my agent. And therefore, I am liable for the torts caused by my employee. Same exact scenario here. So why is this a problem? Why is this potentially catastrophic? Because negligence is going to carry to me as the owner of, now when I say me, I mean MBK Chapman, but I'm the sole shareholder of the firm, so I say me, okay? Well, here's how it affects real life, because this happens every single day. HOAs all over California every day hire contractors. And I can't tell you the number of HOAs that try to skimp, because contractors are more expensive. They're routinely known for gouging people, I have found an amazing contractor that I use for all projects in my home, and I will never let them go. And when that person retires, I've already got plans for who that person's successor is, because it was the foreman that led all this stuff. That person's the one taking over the company. I made sure to ask, because once you find a good contractor, an honest and good contractor that does a good job, takes pride in their work, you do not let them go all the tea in China. Yeah. And I am now set for life, okay? As long as I stay in this area. So they are worth their weight in gold because there's so many bad ones. So here's what happened. This was a case well before you got here, several years ago. We had a client that owned a couple of hundred acres in either northern or northern central California.
Okay.
Rural type land.
Yeah.
He had several structures on the property, including a barn, a big barn, actually a couple barns, but one in particular, the bigger barn. Okay. And he used this land for, among other things, he used it for hunting. Deer were plentiful in the area. So he would have friends up there all the time, staying in these cabins there, and they would hunt. He had for many years used a licensed contractor. And the first time he hired this contractor and times afterwards, he had checked this person's licensure status, and the person was licensed. There was no issues, and the person always did good work. This contractor always did good work. So he hired him again and again and again, and this was just one other time. And on this particular occasion, our client had used this contractor on several occasions previously, didn't actually look at the status of the contractor's license. I don't remember to this day whether or not the contractor in question at the time knew about this issue or not, but it turned out that sometime between the prior time that our client had used this contractor and the present time, the contractor's license in California had lapsed. Meaning, for all intents and purposes, this was an unlicensed contractor. And I don't know whether or not that contractor did it on purpose or just thought they were licensed or forgot or wasn't aware that they had not done something that caused them to be to go out of inactive. That wasn't suspension. It was just inactive. Maybe they didn't re-up. I don't remember. It's been too many years. But the long and the short of it is this: for the purposes of our discussion, he was not licensed, and our client had no idea. So this person was hired to perform work on repairing one of the barns, the big barn. There was a lot of specific, some of the walls were crashed in, there were holes. They had to repair the roof. There was a good deal of work to be done. I'm only giving you some of these details because they're important as to how this ended up, but I'm not going to go into a lot more detail on this because the way I got my client out of the case was what's the word I want?
Technicality?
It was a technicality at best, okay? And I don't want to focus on that because it could have very easily gone the other way. But anyway, in past events, there had been, as part of the contract, the contractor had obligations to either haul trash away or to burn the trash on the spot. And they had permits to do that. It was at the time, I don't know if it's still that way now, but this was, 9 years ago. But they had rights to burn trash on the land. Anyway, it wasn't one of the course and scope duties for this particular job. It was just repairs on the barn. There was not supposed to be trash burned. But anyway, the contractor had done that numerous times in the past. And so in this occasion, there was a bunch of wood that they had taken down that was rotted or whatever. And rather than hauling it away, he decided to burn it. In addition to that, there was several deer antler pieces that still had flesh on them. And they had caused a stench. It wasn't quite all rotten away, and it was causing a stench in the barn. And so the contractor wanted to take care of that because he was spending 2 weeks in the barn and wanted to kind of get rid of that odor. So he put those in the fire to burn the flesh away. Long and the short of it is he lost control of the fire. There was high winds, I guess, whatever. It got away from him. And before he knew it, the fire was spreading. After a couple of days, the fire had burned, 2,500, 3,000 acres.
Oh, wow.
CAL FIRE eventually put it out to the cost of about $3.6 million. They sued our client for $3.6 million. And specifically in the complaint alleged the labor code section we just talked about, alleging that our client was responsible for the negligence of the fire, because it was a negligence that it got away. There were safety protocols that should have been taken that would have prevented the fire from losing control, including maybe not lighting it in that area where the wind was or whatever it was, making a fire break. There was a lot of things that if you're going to burn, you're supposed to follow certain rules. Having water source nearby, didn't do it. Negligence, accidents happen, but it doesn't mean they're not negligent. Well, this person's unlicensed, therefore your client's the employer, responsible, pay us $3.6 million because that's what it cost CAL FIRE to put out this fire. That is an amount my client certainly couldn't pay, didn't have the wherewithal at the time to pay $3.6 million. That is catastrophic. It would have been life-altering catastrophe financially for my client. Even selling the property at maybe $2.5 million wouldn't have covered it. There would have been over $1 million left. He had a balloon policy in effect that partially covered, but only up to $250,000, $350,000. I can't remember the amount, but it was a sliver. And they stepped in, but their liability was going to be maxed out at that very small amount. This could have been life-altering, right? Now, I got us out completely. I got my client out for $10,000, which was covered by the insurance, on a technicality, purely based on the lack of course and scope, and being able to argue that there was that what the contractor did went beyond the course and scope of the contract.
Yeah.
I was able to convince CAL FIRE's lawyers that was a winning argument, and I think it was. I don't remember the other details or what made that argument, if there was anything else that made it a winning argument, I can't remember, but I just remember that being the main issue. Fact is, though, and here's my point, that technicality is a technicality. It could have very, very, very easily gone the other way. This could have been the prior time when part of burning the trash was part of the contract, and that would have been unavailable to us. So It was just by the grace, that it happened to be
good fortune,
that we got out. So I don't want to focus on that. What I want to focus on is how this could have turned out for my client. My client could have lost everything. They would have had to sell that property and probably their house to pay this judgment, which would have just collected 10% interest. And the state of California is not going to let it go. And CAL FIRE is the state of California. It's the government. So this is real, and it can be massive. And why do I tell a story like that?
To highlight the importance of
why is the HOA? Why does the
potential?
Why does the homeowner have to worry about the HOA being liable?
Because ultimately it's the HOA and the membership, including the homeowner, who could be on the hook for a massive judgment, right? If they're derelict or grossly negligent.
You had a case.
Yeah.
Tell me about this case.
Well, this was many years ago at a prior law firm, which was actually HOA representation. But the short of it, without betraying confidentiality, was there was a Cal OSHA component. It was a tall, high-rise condominium building. They retained a contractor for window cleaning. I mean, someone they work with rather routinely, actually, surprisingly, but there was not full vetting by the board of them.
But they didn't check insurance.
And so there was no workers' comp. And one of the, I believe it was a subcontractor. One of the subcontractors, unfortunately, fell to his death, and there was a wrongful death claim against the HOA. They tendered to insurance, and long story short,
hold on. The insurance, you were telling me before, the insurance wasn't sufficient. So
the insurance wasn't sufficient. So this was an actual litigation case. They filed a lawsuit. It got tendered to insurance. The insurance was not adequate to cover the amount in dispute.
So let me interrupt you.
Yeah.
Let's assume for a minute, because I know you said the case settled.
It did.
Let's pretend it didn't settle.
Uh-huh.
Let's pretend it goes to judgment. Jury finds in favor of the worker that was
and that's the whole
killed.
point. Yeah.
Okay. Let's say that happens. Let's say damages awarded are $2.5 million and insurance was $1 million. Okay. That leaves $1.5 million unpaid, right? HOA liable, right?
That residue, that deficiency is going to be a judgment against the HOA. Okay. And guess what?
And what happens? Who pays?
Special assessment, or in some rare instances possible, loan that is carried. The burden is jointly shared by the entire membership.
In other words, you, homeowners listening, are liable for that extra $1.5 million worth of a judgment, and you're going to pay it one way or another. Either your HOA is going to pay it in a lump sum by specially assessing, and that's literally dividing the $1.5 million by how many homeowners there are, and however many members in your HOA, divide that, there's your amount.
Yeah.
And you're going to write a check. Or if your HOA is lucky, maybe it gets a loan, but at some point, maybe it's a 5-year, 10-year loan, so it stretches out payments, but they're going to have to raise general assessments and then maybe do some special assessments to cover, because that interest and principal has to be paid by you. Mm-hmm. One way or another, you, the homeowners, not this nebulous HOA, that's you. You're going to pay out of pocket your pro rata amount with every other homeowner involved. Now, there are scenarios where it's not just the HOA that gets sued. It's you as a homeowner. I'll give you an example. In his example, the HOA, this was solely the HOA, and it was a condo, and they were cleaning the windows, which in almost every condominium, the exterior windows are the responsibility of the HOA. Mm-hmm. So it wouldn't impact any individual homeowner. But I could see a situation where, let's say there's damage done to your individual unit, your individual property, by an HOA component, and they have a contractor going in to make repairs to your unit because they owe you that. And now somebody gets hurt, or they back their land mover, their huge machine into your neighbor's car, and they crush the Mercedes or whatever it is that happens. And now that innocent person is going to sue you and your HOA. Now, your HOA should, in every single case, indemnify you because they're the ones in privity of contract. But you know as well as I do, a lot of HOAs will play games. And so you might have to compel them to indemnify you. And that's going to require you to pay initially out of pocket until we get it back from them. Point is, it's a hassle you don't need. Okay? Under the law, you are required let's get into this employer thing. So under the labor code section I referenced a few minutes ago, if they're unlicensed, you're the employer. If they're licensed, like in that case, yours, but they don't have workers' comp, there's a couple of other labor code sections that happen to fit. 3706 and 3708, still the labor code. And that's what happens when there's no workers' comp. Mm-hmm. It doesn't even go into licensing. It's just no workers' comp.
Yeah.
Okay? And what that does is it basically specifically empowers the injured worker, or in your case, the family of the dead worker,
right,
to sue the homeowners and whoever's the hiring, so the HOA and the homeowner, for negligence.
Yeah.
Okay, and the negligence is you didn't check for insurance. That's the negligence. No problem with the license, that exists, but they're in violation. Your contractor's in violation of the law by not having workers' comp, and you didn't check. And if you didn't check, you were negligent and you're liable. That doesn't mean you won't cross-claim against that stupid contractor or your HOA. If you're the homeowner and you're named, you're going to cross-claim against both. But you're still a party, and you have to defend.
By the way, it's worth mentioning that you don't only check for...
Hold on. And hopefully your home insurance will cover your defense, but that means your policy is going to go up. All right, go ahead.
I was going to say, this is probably a moment worth mentioning that you don't only check for workers' comp, but also general liability coverage.
Yes, thank you.
And that's going to be huge and critical because any shortfall in terms of any potential payouts, you need that to kick in.
Here's the bottom line. It might not be required necessarily, but
that's right. Yeah.
You're a fool if you do business with a contractor that doesn't have insurance.
That's right.
Okay?
Yep.
I'm not talking about workers' comp. I'm talking about general liability insurance. Now, here's the thing. It has to be in a sufficient amount. That's up to you to decide. You might say, I want you to have insurance of $3 million. And if the normal insurance that this contractor carries is $2 million, they'd have to get a rider for one job. Insurance companies can do that. They can write an insurance policy that covers one job because that job is important enough to this contractor. He doesn't want to lose it. I'm going to go ahead and get an extra $1.5 million coverage because you're demanding I do it and I want your business. That does happen. Okay. So, and it's easy to do. It's just a rider and it's a one policy, one job. But another important thing is you, the homeowner, or the HOA in this case, needs to be added to the insurance policy as an additional insured. That's standard practice.
Right.
Okay? Now, let me tell you about the lack of the workers' comp issue. It's not just that you're going to get sued for negligence. It's much, much, much worse than that. Because the code specifically states, the labor code states, that it is a presumption that you were negligent. In other words, the burden has shifted from the plaintiff to prove negligence to you, the defendant, to prove non-negligence in the case of not verifying proper workers' comp insurance. In other words, the code specifically places a presumptive determination of negligence against the homeowner or the HOA, depending who the party is, okay? Presumption of negligence. That burden has now shifted, and the plaintiff doesn't have a burden of proof. The homeowner / HOA now must prove non-negligence.
It's that serious.
More likely than not.
Yep.
That is a major issue. That's Labor Code 3708. This is a very, very big deal because if you are determined to be liable, you or your HOA will pay. Okay? Now, let's assume your HOA indemnifies you. You're both sued and they indemnify you. It's still you because you're part of the HOA. You and your however many neighbors. Very simple math. What do we have to pay divided by how many units? That's the number you're going to pay. Okay? So, why do I say that the statutes I've cited, 5200, the government, the Business and Professions Code sections and the 3 Labor Code sections, why do I say that although they don't specifically state that homeowners have a right to make these demands before work begins, why do I say that the law pretty much implies it? It's a good question. Thanks for asking, Sam.
Well, here's the answer. You can reasonably glean and extrapolate from all of that the statutory scheme essentially provides what's tantamount to or analogous to an affirmative requirement for this almost.
Because 5200, and he's right, because 5200 requires the HOA to give you unredacted copies of all such contracts and all such insurance policies. And because Business and Professions Code 7048 and 7058 require, respectively, licensure and specialized licensure, and because the Labor Code has gargantuan consequences for failing under 2750.5, right, and 3708 on having the license and the proper insurance,
right?
Because all 3 sets of laws have such powerful requirements that it is inconceivable that the law wouldn't place the duty of actually proving that on the HOA. Because if they don't have to show you, then you can't ever verify that the right's being honored.
Correct.
You understand?
That's exactly it. Yep.
So you have a right to, in my opinion, because the law imposes, 5200 gives you the rights, and the law imposes obligations under their Business Professions Code and the Labor Code to then ban you from being able to check before it becomes an issue. Once they're on your property, liability can attach. It's only before they get there that liability, it's no harm, no foul. So if they're not obligated to share that with you before you allow them onto your property, then you could be held liable for something that you didn't do And you put them on notice that they needed to avoid. And if you have a dumb board, which is unfortunately very frequent, that's a recipe for disaster.
Mm-hmm.
Okay? So Labor Code 3706, Labor Code 3708, Labor Code 250.5, I think. Okay? Business Professions Code, Civil Code 5200, all of these things working together, whether they be obligations owed to you, the homeowner, 5200, or the other ones, obligations owed by the HOA, would have to require them to give you the information before anybody stepped foot on your property. Otherwise, they would lose meaning. And so that's why I make that argument. Now, what should homeowners request before work begins? We've talked about some of them, but let's lay it out. What should they ask for?
Perhaps copy of the contract, including the license number, the name of the contractor, so they can
full legal name of the contractor.
Look them up on the CSLB.
Whether it's Bob's, let's say it's a roof, Bob's Roofing Company, or Bob Smith, and Bob Smith DBA, Bob's Roofing Company, whatever it is.
Yep.
You want the name, okay? You want their address, okay? You want their license number.
Right.
You want to see a copy of the signed contract between who?
The association and the contractor, the
Bob's,
roofing company.
Right, Bob's Roofing Company.
Yeah.
You want to see I'd like to see proof of workers' comp insurance in the form of a currently dated.
Yeah.
I'll take a declaration page.
Which, by the way,
or certificate of insurance.
Should be readily available to them, so there's no increased onus on the board.
Actually, the HOA has to ask for it.
And if they don't have it, that's a red flag.
Right.
Yeah.
So you have a right to the certificate of insurance, and you want to see your HOA as an additional insured. Maybe not required, but boy, oh boy, is it dumb not to be.
Agreed.
Okay? You want to show not only certificate of insurance for workers' comp, but you want to see the certificate of insurance for at least some general commercial liability. That's what you want to see. I want name of the contractor. I want the contract license number. I want their professional address. And I want proof of both kinds of insurance. Give me that. None of those are surprising. They should all be easily available within a day or two.
Yeah.
Assuming that contracts have been signed, it should have already been requested and provided at the time of signing.
Right.
Okay? Now, we know, because of what we do, that bad HOAs are routinely going to circle the wagons and say, no, you don't need to know that. How dare you ask for that? We know what we're doing. You're just a homeowner. Yeah, too bad. Okay? So what do you do when the invariable bad HOA says no? Or you can ask for it under 5200. We're not going to give it to you. We're going to wait our 30 days. We're going to give it to you, or maybe we won't. We'll see. Whatever the answer is.
Yeah.
What do you do?
Well, a couple of good first steps would be you make a demand on them, obviously in writing to document it. You can make an IDR request. You can
before that
band together with a membership.
And I would start with this, and then we'll get to what you're saying. I would start with an unofficial email, real nice, saying, hey, you're about to start work on that involves my house. Can you please provide me with the name of the contractor, the license number, and a copy of the certificates of insurance for general liability and workers' comp that they provided to you? I'd really like to see that before work starts.
Right.
And that's it. Leave it at that. Very nice. They say no, then the next step would be to do a formal 5200 demand.
Right.
You can go into my book and figure out how to do that, or you can come to us, MBK Chapman. We'll handle it. But do that in writing, obviously.
Right.
And then, of course, it implies you're putting them on notice, aren't you?
You are.
The way you brought that
You
up.
absolutely are.
Okay.
Yeah.
And if they refuse either the informal demand and the formal demand, or they refuse your IDR demand,
right,
I would do two things. I would send a follow-up and saying, under no circumstances am I authorizing any contractor to enter my property or in my property, enter onto or in my property until you've complied with this or my 5200 demand, whichever occurs first.
right.
And in the meantime, that's when you contact us. Because at that point, if you haven't already done a 5200, we'll prepare a formal ADR demand under the auspices of the Davis-Sterling Act, not just a demand that can be ignored, an ADR demand, which carries with it statutory penalties for ignoring it and specific statutory timelines in which the HOA is obligated to comply within. And that's under the idea that you're probably going to be required under the Davis-Sterling Act to seek ADR for this kind of legal action because there's no money damages yet.
Right.
So you're probably going to be seeking deck relief or writ relief, and that's going to require you to submit to ADR, which under the auspices of the Davis-Sterling Act, we're talking about this specific kind of ADR, it's going to mean mediation. That's what it means.
Mm-hmm.
It's nothing to do with IDR. This is ADR, okay? And you need a lawyer for that. We've done a previous podcast on why that's the case. I also have a couple of articles on the subject. Bottom line, folks, is this. Before anybody steps foot on your property, and presumably before anybody steps foot on HOA property to conduct work that requires a contractor's license, it behooves, if your board isn't doing their job, it behooves you and your fellow members to determine whether or not the person has a requisite license and has at a minimum, the necessary workers' comp insurance to comply with the law. Because if they don't and something happens, you and all your fellow homeowners are going to be liable for every single dollar of injury that's assessed against your HOA in any court case. Mm-hmm. It's that simple. It's going to come out of your pocket, and the way to avoid that is make sure they're licensed and it's not the handyman doing the work. And make sure, and it's not some unlicensed person, it's licensed and they've got insurance. And it's easy to find out. One of them should take 5 minutes once you have a name or a license number. You don't need both, but you just need one of them, and you can find out everything you need to know. The other one requires cooperation from your HOA. Right. If you like this episode, please hit the like button. And if you haven't already done so, please subscribe to the channel, HOA HELL. If you'd like to leave a question like this very, very intelligent person did early this morning, or you want to leave a comment, please do so. We love to read those. And as you can see, we do respond and react when we get a question that we haven't already, done a show on, or something that's new and unique. We'll approach it and we'll deal with it on air. Until next time, though, have a great day.